Hey everyone, Harry here to talk about the really forceful pushback that several law firms have done against the series of Trump efforts to make really big, rich, well-heeled firms to bring them to heel and make them give legal services to his preferred causes and make them scrap or greatly modify their DEI policies and the like. These efforts would be much more effective if they were done in concert, and it's an overall indictment of the legal system and especially big law that the firms as a whole have not been able to band together. There's been a concerted behind the scenes effort to get the biggest firms to sign on to a brief being prepared by former Solicitor General Don Verrilli about the unlawfulness and outrage of these orders. But the richest firms have declined one after another to sign on. More about that in a bit, but let me just tell you about what the more gutsy and principal firms have been doing. And it's been about even Steven between capitulators and fighters. And Trump has, been benefited from a sort of one at a time divide and conquer strategy. But even so, some firms have been quite strong. And those, by the way, would be Perkins Coie and Wilmer Hale and Jenner Block. And they have, so already one of these efforts, the overall kinds of the action by Trump that the firms have been capitulating to involve lots of money, and the price tag keeps going. That's what happens when capitulators capitulate, is it makes the next one easier and makes Trump's terms more severe. But now the price tag has gotten to about $100 million worth of pro bono services, and especially to Trump favored causes, as opposed to the causes that some of these firms have been favoring, which is totally their right. These are identified as progressive firms, and that's the kind of causes they've done. Now they're agreeing to do things that Trump likes, and likewise on the DEI stuff. But we've already had one order involving Perkins Coie enjoined while Judge Beryl Howe, who's got the case, decides whether to make it permanent. And her opinion in joining was absolutely scathing to the administration. She actually said in open court, "This gives me chills, these things, this order." It should give everyone in the legal profession chills. Pretty good op-ed in Sunday's New York Times from a well-known trial lawyer, John Kecker, who actually was the guy who tried on behalf of the United States the case against Oliver North in the 80s. But anyway, just basically making the point, if we stand together, we'll be okay, and if we don't, we'll fall. And the ones who have knuckled under have basically made their own financial calculations and completely neglected the broader principles of the rule of law. Not so everyone, however, and let me just focus most recently on what's on Jenner Block, which is riding the wind from has the advantage of the backwind from what's happened with Perkins Coie and Judge Howell, but has now come in itself with a really forceful long brief that points out what is unconstitutional about these demands from the administration, and it just is. You can't, it's not exactly fits the legal definitions of blackmail, but that's essentially what it is, or you could say a sort of protection money racket. But to force them to do things that just really damage the rule of law, and not just these law firms, but our whole system, our whole legal system, which is premised on parties from either side litigating aggressively, giving their best arguments and having everyone be able to choose their counsel. It's exactly what this kind of hits right at the heart of. The idea is to keep a lot of people from having the counsel of their choice, and having different firms get a kind of scarlet letter from the administration that even if, and I think when, Perkins Coie and Jenner Block succeed, still remains because, big clients who are betting the company will have to flinch or hesitate because they'll know that whether or not these guys won, maybe even more if they've won, they are not in the good graces of the administration, and this administration is corrupt enough to make people pay as a result. Indeed, the entire effort here, the firms that he's gone after, there's not even the slightest pretense that there's any legitimate executive branch function, much less the whole underpinnings that this is something to do with national security is, not to put it too delicately, a bald-faced lie. There's no way in which Perkins Coie or any of these firms threaten national security. What they do, however, what they've done is somehow aid Donald Trump's enemies, and so inspired his thin-skinned ire. So one hired Andrew Weissman after he left Bob Mueller's employ. He's long since left. Perkins Coie, there were a couple lawyers there. They've long since left, who filed very effective actions against Trump in Trump 1.0. Skadden Arps has an association also with Mueller through a sort of triple bank shot. But the whole thing is not just illegit, not just a lie, but really revolting, right? For that, the president personally so corrupt as to try to just materially harm firms for the sole reason that they were on the other side from him, which, can I take a step back, is an absolute assumption of the criminal justice system, right? Everyone gets, and including Trump, he had representation of his choice. Okay, but the Jenner brief says, look, this is an unconstitutional abuse of power against lawyers, their clients, and the legal system. And it really is true. It's intended to hamper the ability of individuals and businesses to have the lawyers of their choice zealously represent them. And it's intended to coerce law firms and lawyers who have normally a free First Amendment right to do what they want to do, into renouncing the administration's critics and ceasing certain representations adverse to the government, whereas a healthy and lawful justice system would, of course, every big firm, some of its greatest moments are precisely litigating against the government. No one would doubt it. No one would begrudge it. No one surely would penalize it before Donald Trump. But let me just unpack the three groups briefly, and then bring you up to speed. So obviously it is a absolute hammer on the lawyers in those firms. They're being threatened possibly with ruin. Though if you have a lot of practice before the government and you're persona non grata with the government, it could kill you. I think people think that Perkins Coie even fighting is in existential crisis because so much of its practice has to do with things before the government. Clients, right? There's a Sixth Amendment right here that lawyers have standing to invoke. You're someone who wants to have the best lawyer. You've always used Jenner Block, and now they're essentially taking that away from you and compromising it. That's a literal injury that can be redressed by courts. And then the broader society won't come in and sue, but it's just essential to understand the sort of attack this is on the whole justice system. Free democracies do not have their biggest firms have to kowtow to the maximum leader and adopt a party line. On the contrary, they're there to play whatever role they want in society and let the market and the private sector reward or penalize them as they will. But when you have big concerns like this, and it's also in media and the academy, who are having to genuflect and provide lip service to the administration, you're a long haul down the road toward an authoritarian big brother-like society. So for all those reasons, these orders are both unlawful and pernicious, and we have to completely hope that they'll be reversed. And then even so, the best that could happen would be all the firms banding together to have, a united front and keep it from happening. As of now, the prospects for that are not great, although the efforts continue behind the scenes. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.